Well, thank you for joining us on the program. This is Voice coming to you from Ben Television. My name is Tunde Alabi. On the program today, where we take a look at legal matters in the United Kingdom. And on the show today, without the waste of our time, we'll be taking a look at immigration issues regarding a leave to remain application and cancellation. When you put in your application for leave to remain, either you're renewing your application for a leave to remain or you're putting in a fresh application for a leave to remain, what applications you got to have in there and what happens when you have to cancel your application or your application for leave to remain is rejected or cancelled or is made out of time. What do you need to do? What kind of legal advice do you have before you put in your application, or when you have an out-of-date application, or you need to renew your leave to remain? You know, considering different circumstances that may be around your leave to remain. So these are some of the issues we'll be taking a look at on the show. We do hope you're going to enjoy and have some basic information on the program. If you do have query, the best to do is to reach out on the phone number that's going to be put on the screen. You can send us a text message or you can send us email on the program, Jennifer at Obaseki Solicitors, or the info, or you can send me an email, Tunde Alabi at obasekisolicitors.com. Tunde Alabi at obasekisolicitors.com. We'll be able to treat your queries. Better still, speak to Citizens Advice Bureau or get in touch with your own solicitor. But we're here to help you, and that's why we're here. My guest, as usual, on the program today is Jennifer Obaseki. Jennifer Obaseki is the senior partner at Obaseki Solicitors, based here in London. She'll be taking a look at this topic we've spoken about today. Jennifer, thank you for joining us on the program today. Right, let's quickly take a look at a leave to remain. You want to speak us through this?
Now, in the UK, we have different categories of leave to remain. Most popular for those who are not entering the country lawfully and getting a qualified right tends to be the 2.5 years discretionary leave to remain. And when I say we have different categories, it's because you don't automatically just get indefinite leave to remain.
Yeah.
That comes about normally when you spent 5 years as a parent of a child that's British and been here lawfully extending. However, if you start from an irregular, unlawful position where you've overstayed and then you become a parent of a British child, you might then be placed on what is called a 10-year route. So it's very important that you, once you get a form of leave to remain, you know exactly whether you can shorten the time length before you get indefinite leave to remain, or whether you have to stick to the 10 years. So for example, if you are undocumented initially, you manage to get 2.5 years leave to remain, and then you're placed on a 10-year route, can that be shortened if you get married or become a parent of a British child? There is an argument for it to be shortened to the 5-year route, and that is after you go for renewal, you make submissions to the Home Office, or when your circumstance changes, you outline the fact that because you're now in a legal standpoint, going forward, you should not have to be on the protracted route. It should actually be the shorter route, and also it should be considered what's in the best interest of the child. Again, when you get married and you're in that position, should you be treated as an overstayer in a discretionary fashion, or should you be treated as a spouse that's here lawfully? So again, you should argue for the period that you have to spend before getting your indefinite, not be the 10 years, but should be the 5 years, because your standpoint, your starting point has now changed. And we talk about this because many people have seen the different forms. You've got Set O, you've got Set ILR, there's different settlement application forms out there. And making sure that you actually, after a period of discretionary or limited leave to remain, then complete the correct form for indefinite leave to remain becomes quite important. And when you have your indefinite leave to remain, yes, after a year, so far as you have spent between 3 or 5 years, depending on your circumstances here lawfully, you should be able to apply for your naturalisation. Now, the reason why we want to really talk about this topic is because, again, children who've been in the United Kingdom for more than 10 years that were born here can also, again, apply for naturalisation rather than leave to remain. So it's like them skipping a step. So if you're eligible to skip a step, again, it becomes important. So people who are stateless, people who may be able to apply because of the fact that their parents had a level of British citizenship, so that's from either British Overseas Territory or British colony, one of these types of older style British citizenships, you may be able to, again, avoid having to apply for limited leave to remain, indefinite leave to remain, naturalisation, and go forward. So it's very, very important, and we've seen this more so because of the Windrush scandal, that many people that were even brought over without documentation should be able to apply for citizenship if their parents were travelling on a particular type of passport. Again, so many people, let me say, get this bit about naturalisation and British citizenship wrong. So if there's a chance, it's best to check properly to make sure that if you are eligible for a higher and better status, that you go for the right thing.
Okay, and this information that you have just given may be kind of new to some of our viewers that are watching this program, not knowing that they can actually shorten the route they have if you are in a 10-year rule.
Yes.
But if your circumstances suddenly change, you can shorten that route to 5 years by virtue of your marriage or having a British-born child. But the question I have to put to you is that someone has limited leave to remain, having renewed first or second time, now gives birth. Does that child automatically qualify as having British born? Or
No,
having British
it's only if you have
passport?
indefinite leave to remain and you give birth to a child. You cannot automatically pass any rights of leave to remain to your child if you have limited or discretionary leave to remain. And this is one of the reasons why we are desperately arguing that the application fee for children be reduced, because the burden of renewing for yourself and for a child is astronomically high. It means you're pushing to £3,000 just for the two of you, and that's very unfair, given a child doesn't really need security checks, doesn't need background checks. What background checks does a baby need? So arguably it's very harsh, but the child will actually have to apply for a form of leave to remain. And because it is harsh, many families are actually not making the applications if there's no intention for or need for the child to travel, because spending £1,500 just for a child to have a document is quite extortionate. So moving forward, if the child is in the country, hasn't made any type of application because the parent only has limited leave to remain, what we're finding is people are waiting until the child is actually not just 7 but 10 years old, and that's become quite common because the 7-year rule is not strict anymore. It's only if you can show that your child cannot re-establish or resettle in the country of origin that you're expected as a parent to return back with the child. So it becomes difficult. Talking about leave to remain and the fact that if you have indefinite leave to remain, it's not permanent. You know, it can be revoked. It can be stripped off you. And this often happens when there's been a criminal conviction. Once somebody is convicted of an offence and spends more than 12 months in detention, their leave to remain indefinite can be revoked. And I've given examples on the programme before. So when we go to visit people who are detained, especially younger people that don't appreciate that, it can be taken from them. Many of them say, but, you know, miss, I've got stay. Why are they sending me this? And you see, the Home Office normally sends a letter of intention to revoke, and it's due a reply. But often prison officers don't advise detainees, especially people who have been convicted, of their legal rights you actually have to seek proper legal advice and respond to that letter from the Home Office outlining what your connections are in the UK, and the fact that if you haven't been in your country of origin, haven't been there since you were a baby, or have no connections, that your human rights are likely to be breached. People have to fill in that form robustly, so robustly, because your only right of appeal is often really one that is maybe out of country, and also it may also be a submission that has to go before a High Court judge. So the submissions have to be substantive. That means if you are in detention and you're facing a sentence of more than 12 months, it's quite important
and you hold a foreign passport.
And you hold a foreign passport.
Even though
you have indefinite leave to remain.
You're still a foreign national.
You're still a foreign national, and it doesn't mean that you cannot be asked to leave the country. If you have children, it's important to show that whilst you're in detention or serving a sentence, that you're maintaining a relationship with them. That's phone calls, that's visits, and often people are unfortunately detained far away from their homes. So vulnerable families, without one parent already, having to meet the travel costs to go and visit. Often people are quite ashamed, don't want their children to see them in detention facilities. So you've got to get over that and try and make sure that you can show on paper to the Secretary of State that you are maintaining a relationship with your friends and family members. And if there is no connection in the country of origin, showing that is also very, very important. And it's a hard thing to show on evidence-wise. But with other people that are related to you, giving testimony that you've not been there, that the relatives don't know you, or all relatives have migrated out of the country, is also very, very key. But most importantly, it's to show that you're a person whose character has changed, that you're reformed. Because the idea of revoking your leave to remain after a criminal sentencing is usually to show that you're a person that is not conducive to the public good, that you're not welcome in this country, that you're a danger to this country. So showing that you are a reformed person, that you are rehabilitated, that you've shown not penance for your sins, but basically that you have made amends, it goes a long way. And the nature of the crime also does go a long way. Certain prolific offenders up before a judge, if you've got 3 convictions, a judge might look at it and look at when you carried out these convictions, your circumstances, and may have a level of empathy, but the law is the law. But if you're a prolific offender, 15 offences, all very similar, it shows that you are a danger to the public, or your presence in the UK is not conducive for the public good. And showing, let me say, evidence to combat that is very, very much so key. So we're talking about showing that maybe you've attended courses, probation reports, extra activities that you may have done whilst in detention, all become very, very essential. But more so, it's really down to your human rights and showing those key relationships with children who may not be able to maintain a relationship with you if you're removed. Dependent adults who may be disabled or vulnerable to some degree, and again will not be able to maintain a relationship with you. And again, you as an individual showing that there will be breaches to your private life, and that the decision would be wholly unreasonable given your circumstances.
Right. Before we go further, let's treat this very well. Very many people think because they have indefinite leave to remain, they can do and undo. Do you want to emphasize the fact that you have indefinite leave to remain? You're still a foreign national. You commit crime, a serious crime, financial crime.
It's not even just crime. It could be
a
series of civil offences. It could be indebtedness. Now, when you look at the application forms, they actually ask for civil orders against you, not just criminal convictions. So it's if you haven't paid child support and you have a series of children, that could also be an issue. A judge may look at that and say that you have no respect for public decisions, you have no respect for authority. If there's a series of civil issues in relation to your presence and being in the United Kingdom. Not saying that if you don't pay a parking fine you're going to be removed, but on a serious note, one's conduct is being looked at more and more seriously. So indefinite leave to remain, it's not the be and end all. You're still being watched. Your character and an assessment of whether you're a good character is still looked at, especially if you have a conviction or if it comes down to taking that step further and applying for British citizenship. Now, the test for character when it comes down to British citizenship is more stringent than that of when you're applying for indefinite leave to remain. Both have good character tests, but the one that is carried out by the Home Office when you're applying for British nationality is so much more detailed, so much more stringent. So that's why when you're applying for British nationality, you can be seen as a person not of good character, but when you're applying for your indefinite leave to remain, you can be seen as a person of good character. Some people say, why is it that they can say when I apply for my indefinite leave to remain, I was considered a person of good character, no convictions, no civil orders, but when I apply for my British citizenship, they've said I'm a person not of good character. And this can be due to periods that you might have spent working undocumented. They go through HMRC reports, they go through financial reports, they go through criminal DPS checks, and other series of background checks. So you can imagine if you've not got no convictions, no civil orders, but there was a period of 3 years, 5 years that you may have spent undocumented, but there seems to be some evidence that you were working unlawfully, you'd be deemed a person of bad character. Now, or not good character. Now, how to combat this? Number one, if there's no evidence that you were working unlawfully, it's important to send to the Home Office how you sustained yourself, how you were maintaining yourself during that period that you were not documented. And they often ask for this, even when you have your indefinite leave to remain. So friends and relatives that may have supported you during that period that you were not documented may give statements, affidavits, statutory declarations to outline that they supported you. In addition, if you had a partner that was supported you during that period, that person can equally confirm that they did so, whether they have evidence. A lot of these people who are not documented now, I recommend that a lot of them use prepayment cards, like the Cash Plus cards and other cards. Why? So that there's a trail of evidence. There's evidence to show that it's not money laundering, it's coming from somebody who's sponsoring, who's supporting you on your day-to-day needs, and there's a record of your expenditure of your day-to-day needs. It supports, one, you on how you can evidence that you sustained yourself, and it can also show, too, that it's not that you're a criminal, that you've got legitimate funds coming into you from a sponsor who's qualified and able to give you that financial support. It's very stressful, immigration cases can be stressful for people, and we fully appreciate that, especially at our practice. We're very empathetic. So we always try to look for ways that you can satisfy the requirements and easily demonstrate it, because English law is about show and tell. I say this all the time. You're going to be believed if, one, you have the evidence, and two, you have the excellent submission to go with your case. You can't just get it just by asking. You can't get things just by asking and say, yes, I qualify. You actually have to show you qualify with evidence and tell by telling the correct submission, applying the correct legislation and rules to your situation, and telling your facts. It's also very subjective. And then there's that caveat of discretion. You see, we have this ability in English law, especially with immigration law. The Secretary of State has this power of discretion, that even though you meet 98% of the rules, I'm not going to refuse you. I'm going to use my discretion to enable that you qualify. So if you know that your situation is bad, let's say we know that you only satisfy 40% of the rules or the eligibility criteria for an application, you have to realize that you're taking a gamble. I don't know, if I sit down and say, Tunde, give me £100, you're only going to get 45 back. Will you give me the £100?
Absolutely not.
You don't trust me.
Nope.
So it's important that if you're going for these applications that now cost thousands of pounds, that you categorically ask your immigration advisor to tell you what percentage chance of success you have. And I hope that's the best way I can explain it to people.
Right, right.
Apart from giving away the application fee, the legal fees, ask the solicitor the percentage chance of success, because you want 100% chance success on your application. But if there's only 35% chance, 40% chance, then you've got to think carefully. Would you really be throwing your money away for a 50% chance? And most of the people always use that 50-50. No, things are not so 50-50. If the lawyer is credible, if the lawyer is experienced, they'll be able to tell you where you meet the rules, or if you don't meet the rules, and what your percentage chance of success is. And if it's less than 50, please rethink and look at the other options you may have. But since we're talking about leave to remain and naturalisation, you should be starting on solid ground. It's if you've done anything or you're doing anything that's going to shake that solid ground, such as there being convictions, such as there being mistakes or misrepresentations in your initial application. So if you've presented evidence that's not accurate. So for example, in the papers last week in the Independent, we saw that a mother had gone on holiday with her young child, and on return they were not allowed back in the country. Why? Because the Home Office had revoked the son's British passport, and it's very unclear whether the revocation took place while they were on holiday or
I think
before she left.
the woman took a gamble. She didn't actually go with the child. The
child
Home Office had written to her that the child passport had been revoked because new light has been shown that that the process leading to the award of the British passport was questionable. She didn't actually meet certain criteria, and she still allowed the child
to go to Belgium.
To go to Belgium.
Now
that's questionable.
You see,
but I mean, what the point there is, I mean, the woman could take her own side of the blame, but the real issue falls on the Home Office. Here is a chatbot in the United Kingdom.
Spent 6 years
of her life in the UK.
To be quite frank with you, I was so perturbed when I saw the facts of the case, because what should have happened is, it's an expensive process, but an injunction should have been sought to bring the child back into the country. This is that child's country where they've spent the formative years. And if there's going to be a challenge made, the challenge needs to be made while the child is actually in the country. It should not be made while the child is outside the country, because
the child was not allowed to board.
Exactly, but that's why an injunction needs to be sought to bring the child back into the country, based on human rights. So these are things, if you have the right lawyer and you can make the right submissions, then you do things the right way. We've had cases very similar to this and we've been successful. The right way is to bring the child back into the country for human rights reasons. One, for fair hearing. Number two, so that there's no breach of the child's specific right to degrading treatment. Keeping a child outside of a country where it's spent its formative years, where they're going to be distressed separate from their parents, is wrong and unreasonable. The sad thing about that case is the mother's leave was dependent on the child, so both of them were excluded. But correctly, the right way to challenge such a thing, in my opinion, would be to seek an injunction, and this is a High Court injunction, making sure that they have the right to review and challenge the case whilst in the United Kingdom.
Right. Quickly, let's, in 2 minutes because of our time, you are actually heading one of the campaigns now, asking the Home Office to rethink the hostile immigration environment and facilitate a fairer, more liberal immigration policy. Quickly, in 1 minute, what are you aiming to achieve?
Well, what we're aiming to achieve is to give a direct response from the community to the government as to how the hostile environment is affecting us in our jobs, even when there's delay in renewing our applications, the fact that we're losing jobs, the fact that employers cannot take on people from their ethnic community, and the fact that the legislation in itself acts as a form of indirect discrimination against certain vulnerable people in the community.
Right, I'm sorry.
Yes.
I need to close the
So
program
please,
now.
if you can, 12th of September, come to the House of Commons and
We've
also
we
email
yeah.
Tunde Alabi so that you can get more information about it.
We will
Tunde
talk
Alabi
more
at
about
Justice.
these subsequent programs, right? Because we need to go now. Jennifer Obaseki
My
of Obaseki
pleasure.
Solicitors, thank you for joining us
Thank you
again
so much for
and
having me.
adding value to the program. My name is Tunde Alabi. If you do have any query, please send your message to the phone number on the screen. Thank you and enjoy the rest of your day and stay out of trouble.